Hello and welcome to The Pulse, the show where we talk about issues concerning us, the people, and having a bearing on society at large. I'm Tina Jha. On the 22nd of January 2020, the Union government moved the Supreme Court for fixing a 7-day deadline for the execution of death row convicts. In its plea, the ministry sought a direction from the top court in fixing the deadline for filing of curative pleas after the rejection of their review petitions. The government wants the apex court to introduce a 7-day deadline for death row convicts to file mercy petitions. If the convict of death sentence wants to file a mercy petition, it would be mandatory for a convict of death sentence to do so within a period of 7 days from the date of receipt of death warrant issued by the competent court. The government also has asked the Supreme Court to order all courts as well as the state governments to issue death warrants within 7 days of the president rejecting the mercy petitions and also to execute them within 7 days, irrespective of the status of any petition that the convict may file. It submitted that while taking care of the rights of the convicts, it is also important and need of the hour to lay down guidelines in the interest of the victims, their families, and in larger public interest, lest the convicts found to be guilty of such horrible, dreadful, and heinous offences would be permitted to play with the majesty of law, prolonging the execution of the sentence awarded to them in accordance with the law. The present concern largely seems to have been caused by the multiple petitions from the convicts in the 2012 Delhi gangrape case and a consequent change of date of their execution. Now, these delays are once again giving rise to public ire, leading to demands for fixing a time frame in the administration of justice. So on The Pulse this week, we are going to talk about the factors that lead to delays in death sentence executions. Is there a need to fast-track death penalty and the legal entitlements of the death row convicts? Joining me on the show today are Archana Pathak Dave, she's Advocate Supreme Court. We also have with us Lalita Kumaramangalam, she's former Chairperson, National Commission for Women. Next to her is Dr. Charu Vali Khanna, she is also an Advocate Supreme Court and also a human rights activist. And besides the three ladies on the panel, we are also being joined by Mr. Ellen Rao. He is former DCP, Delhi Police. I welcome all the panelists on this edition of The Pulse. And besides, we also have with us some members in the audience, some young students who will also participate with us in the discussion today, put forth their views and also ask some pertaining questions to our brilliant panelists. So I welcome all of you on this edition of The Pulse as well. Lalita Kumaramangalam, ma'am, let me begin the show today with you. I mean, the most common, the most basic question that comes to all of our minds in the wake of what's been happening in the Nirbhaya case is, what is it that is leading to delays in death penalty of these convicts who've now, sort of exhausted most of their remedies and they're only trying to delay the inevitable?
What I always say is that India has some extraordinarily good laws. But it's in the implementations of the laws that the systemic injustice that is done to women who are victims of violence is what has caused all these problems. Whether you want to blame it on the lawyers who actually teach these, the criminals, the convicts who have been already given the death sentence, that you have these rights. Whether it's the activists who start talking about the rights of people who have been given the death sentence, often the fact that justice delayed becomes justice denied is sort of swept under the carpet. Now, I'm not saying that the lawyers are wrong or the convicts are wrong. Everybody has a right to fight for their own rights. But the systemic injustice that's done to victims has so far, I think, been ignored. But the courage and the resilience of Nirbhaya's mother and father who have fought undaunted to get their child the justice that she deserves, has brought this this entire issue before the public. And I'm glad that the government has taken steps to ensure that there is timely delivery of justice. Justice has to be timely delivered. Otherwise, what's the point? That poor child has been gone for more than 7 years. And whatever may have happened before, after, that's irrelevant. The court had pronounced the sentence many years ago, more than, 3 to 4 years ago, yeah. And they are still, trying to fight to see that they don't get it. Had the court not believed that it was a really heinous, it was heinous is, I think, sometimes a mild word to use in this case and many other such cases. Now, the argument that death sentence itself is not effective, that's a totally different topic altogether. But once the death sentence has been pronounced, the inordinate delay, it puts off or it prevents a lot of people from actually approaching the court. Indian courts are notorious for, for cases going on and on and on. And here the case was finished so fast. Everything was done. The police did their work well. The judiciary did its work well in time. But then after that, I don't know whether to call it the misuse of the law, but after that, the inordinate delay in actually execution of the sentence is what I think has, made this topic so important today. And it's not only, imagine, this is a case that is in the limelight for the last 7 years. Think of the people whose cases don't ever come before the press or the public. How much they must be suffering.
Definitely. Archana Pathak, the way I want to bring that question to you, as she rightly said that, Nirbhaya case was in the limelight always. It was supposedly a fast-track case as well. Still, it took 7 long years. There must be hundreds of other cases which, where the victims, their families are just waiting years on for justice. And even after, hearing that the perpetrator of the crime has been awarded a death penalty, there is inordinate delay. We've seen in the Nirbhaya case, there are several other cases. As a lawyer, do you think somewhere that under the garb of Article 21, there are lawyers who are representing these criminals, these convicts, they're kind of misusing or taking the judicial process for a ride?
See, I don't see that, we have the laws already in place. So whatever these lawyers are filing, these are not illegal or something. The law provides, and that is why they are availing those remedies. There's nothing wrong in that. The moment you change those laws, see this delay, whatever the, last week the government has now, has come up with this, that, there should be a 7 days black warrant. After the black warrant is there, then there should be 7 days within which you should exhaust all your remedies so that, whatever the final thing is taken. So I think if that is done, then the majority of the problem that we are facing now today, these loopholes in the legal system or whatever, that can be solved. And of course, when you said that there are so many other cases, and ma'am also pointed out rightly that there are so many other cases, very heinous, you cannot actually compare. But yes, last week only there was a case which was going on. So 2008, there was the family of 7 brutally murdered by a lady and her lover, and they have also been awarded death penalty. And the lawyers today, they are saying that they want to repent. I mean, 10 years down the line, still they are waiting for that execution of the death warrant. So there are cases haven't come to the light. We don't know. There are cases for which are pending for the past 30 years. Rarest of the rare cases. Absolutely, the death penalty is only awarded in the rarest of the rare crimes. So you cannot compare, and even now when we talk about these crimes, we have goosebumps. So I think it is extremely important that a quietus be done at a level. There should be a deadline fixed so that these things that one after the another availing the remedy. And I'll also tell you the reason why. See, there are 4 people who have been awarded death penalty, and the case is common. So the moment one person files and the other are not filing, death penalty, there is no returning back. So therefore, this thing is given that unless they exhaust all their legal remedies, or if there is something pending, then that has to be taken care of, and thereafter, it can be executed. So that is also one of the reasons. See, the law cannot be always one-sided. At present, what ma'am said, I quite agree that, it is more accused friendly. I mean, they can use it to their advantage, and victims somehow take a back seat. Because see, one is that you have the government pleader for the victims. Of course, for the complainant side, you can have an advocate, but it is mostly the government pleader who is, arguing for the complainant. And for the accused, they have the choice. They can have as many as lawyers, big, small, whatever, the senior or whatever. So, it is more towards the accused-centric system. That has to be, the whole, the scenario has to be changed.
Okay, I'll come to you, Archana Pathak, to understand how can we, go towards making it more victim-friendly. Currently, as you said, it's more accused-friendly. But in the meanwhile, Dr. Charu Ali Khanna, let me ask you, I mean, the government, all of us, the panelists who spoke ahead of you, talk about this 7-day deadline. Obviously, that will take care of the delay bit to some extent. But will it compromise on the due process
I think it's a good step that finally the government has woken up and they have at least moved the petition. Finally, but 7 days time frame is too little. But definitely we need a time frame, because what is the purpose of a punishment? Whether it's death penalty or life, one is to punish the accused, and the second is it should be a deterrent. Now, if the punishment is not executed, then it's not a deterrent.
Yes.
Like we've all waited for 7 years. And secondly, if it is intending to punish those people, are they really being punished in the true sense? Because I'll give you an example which Archana ji very rightly said, that there are cases which take up to 30 years. This is a case which you're calling fast track. Now, I don't know in which country you call 7 years fast track, but in India we definitely do, so we're calling it a fast track case. But remember, in 2.5 years the trial finished. It has taken 3 years in Supreme Court. So when there's a 90 days time to file a criminal appeal, there's a 90 days time to the convict. We are all saying that it's, it's not victim friendly, it's convict friendly. But I want to ask this question. If the convict is given 90 days time to file a petition in the Supreme Court, then why can the Supreme Court not decide it in 90 days? Why can it take 3 years? After all, the law should be equal for all.
Yes.
So and because of these delays, you see, that's when the court gets sympathetic to the person, to the convict. There's a case of a very heinous crime of a call center operator in Mumbai slums, and she was burned to death. And he was also given a death penalty, but then, he went through the processes and the president's mercy petition was rejected. But you see this, what we're talking about, delays, and I think you will talk, our esteemed panelists will talk about investigation, poor investigation and simple callousness in governance. In that case, there was a noting which had a wrong date, which came from the president's office. On that ground, the Bombay High Court said he spent 7 years in jail and there's been a delay, 7 or 9 years delay in his execution of his hanging. So he should be converted to life imprisonment.
Yes, and there have been multiple cases in the last few years.
And who are these? Remember, when we're talking about accused friendly or whatever, I mean, I don't want to get into that issue for or against. What is the law should be executed? But who are the under trials? Who are these people? They are all from the poor society. The National Law University has said, had their reports, I'm not talking on my own, that most of these people belong to the economically deprived sections of society. See the disparity we have, see the poor and shoddy investigation, look at the caste hierarchies. And 40% of these persons under trials in jail, they are illiterate. Around 30% are under 10. So we're talking about 70% of people who are committing crimes don't even know what the law is. They're uneducated, they don't know the law. Law has no meaning in their life. So how are you going to give law meaning? And also, I mean, I'll just quote another statistics. 24% of the population is around 24-25 belongs to the SC/ST category, and 1 in every 3 under trials belongs to SC/ST.
So then what you mean to say is that,
absolutely,
the law currently for them will not be a deterrent because they're not educated at all, they don't know what the law is.
They don't know, the law has no meaning for them. How can they respect? Do you talk about obeying the law, respecting the law? It has no meaning for them. It's only that 3 years after, for so long, these boys suddenly must have realized, because in this particular case, Nirbhaya case, suddenly every year in December, there's this public ire, hang them, hang them, hang them. So then everybody gets active, and now they know that death is a certainty. So they're trying to, obviously, if your life is at stake, you're going to use every law in the book to save yourself.
And of course, the lawyers, who are defending them are using, maybe I could say they're taking advantage of the loopholes in our law.
That is the law. I won't blame the lawyer. I mean, if I want an advocate, I want the advocate to keep my best interest in heart. So the advocates are doing a good job for them. But unfortunately, that is a law, and we need to rethink on the time schedules of the execution, of filing, of deciding the case also.
Okay, so obviously all of us understand and acknowledge there are some loopholes in the law which are being misused or taken advantage of by some sections. So how can we get rid of them? What are the reforms that we can, talk about in the current judicial system? We'll come to all of that. But Dr. Rao, what I want to ask you is, obviously we can't blame the judiciary for the delays. Inordinate delays happen at different levels, starting with the investigation. So as somebody who's been in the police department for so long, help us understand, why should there be a time limit only at the judicial level? Why can't the police also have a fixed time frame wherein to decide what the case is and strengthen the case in a way wherein at a later stage the convicts can't take advantage of it?
Yes, the investigation is a very important aspect of the judiciary system. Unless there is a very good investigation, you can say the tightly evidence collected in any crime, that investigation all depends upon the whatever has been collected by the investigating officer, and that should also be in a time frame manner. No doubt in our law the time has been decided, a time has been given for the investigation also, and in particular the cases in which the accused persons are in custody. The time frame has been given that if the offence is punishable up to 10 years, then the time frame of the investigation when the accused is in custody is 60 days, and after that if it is 10 years and more, then that time limit is 90 days. But during that time limit, the investigation has to be completed by the investigating officer. Particularly in this case, in the case of Nirbhaya, I must tell you that it was investigated in a very time bound manner, and I think that was investigated within 20 days or 25 days the charge sheet was filed. So after filing the charge sheet, and the trial court also tried this case in a time bound manner, and after that, as rightly said by Mrs. Kumar Mangalam also and all our panelists, esteemed panelists, then the trial after commission, after the conclusion of trial by the trial court in Sessions Court, and then High Court also approved that trial, because the death sentence has to be approved by the Honorable High Court. And then after approval of High Court, then what happened in Supreme Court, and there were 3-4 years inordinate delay in Supreme Court, that is really questionable, and then we are all discussing because of that. But I must come again with the investigation part. The investigation of each and every case, not only a Nirbhaya case or any other case, because in India there are so many other cases which are going unnoticed, unreported in the press. Definitely. And these investigations are also to be taken care of the investigating officers. But in that regard, I will that the investigating officers should be trained. This training is very important to them, and because the new almost daily new laws are coming up, they are required to be made aware of the new techniques, new system, new scientific investigations to be done, and the scientific aid is required for proper investigations, because in every heinous crime, the investigation is to be done by with the help of the physical evidence which has been collected from the
But sir, taking reference from the Nirbhaya case, you know,
yes,
what they're taking advantage of right now, the 4 convicts, is somebody is claiming that he was a minor when the incident happened. Shouldn't that have been cleared at the investigation level?
During investigation, yes, because it was cleared when the one of the accused was definitely a minor.
And delays by, you know, reasons which are drawing public ire, things like the police is not providing relevant documents, and that's why, you know, the execution should be delayed.
No, that is not a part against any police, the police action, because police has completed the investigation within a very time bound manner, and after that there was no role of police, because definitely after that if there is something is required by the court, and the police has to provide it in time bound manner. And again, a time what is time is required for supplying such document which is required. But I don't think that in Nirbhaya case police is at fault at all. And I must tell you that this investigation, this case was totally a blind case, and the special investigation team was formed in South District, and then these culprits were apprehended within 24 hours time with the help of only one video recorded which got the clue about a bus which was carrying these. On the basis of that clue, only all accused persons were arrested within 24 hours, and then investigation was done. And that investigation was so tightly packed, that evidence was so good in that case, and then that's the reason that the court has the court did not find it that this case of any discrepancy, and then these persons were convicted to the death sentence. So that investigation has to be appreciated, and the time taken by the investigation and the time taken by the trial court, that also to be appreciated in this case.
I hope, I mean, in all other cases also, you know, the police investigation is as watertight as you are claiming.
All the cases which are you can say media trial. In that case, police is also doing very good, and the trial was also.
No, I mean it should not. It should not be a matter of concern whether there is media limelight or not.
It is a matter
I mean, I think the police investigation should be watertight in all such heinous crimes.
So many other cases are unreported, unnoticed by the media. These are like anything.
Okay. So, I mean, after taking opinions from all our panelists, let's bring in the audience into this discussion now. Let's take it in the top row.
My greetings to all the panelists present here. I'm Rashmi Tiwari. I would like to put up a question to the sir. Is our forensic system that effective to make the trial and the investigation more effective in the case?
Scientific investigation is investigation which is considered to be the most reliable way of evidence in the trial. So, when we talk about scientific investigation, we mean that the evidence which is found on the spot and which connects the criminal to the crime. That investigation, for example, is the blood is found somewhere on the spot of a murder or any heinous crime. That blood, whether it's blood of the accused or blood of the deceased, that has to be seen by this forensic laboratory. And that if that blood found at the dead body or some nearby or on the weapon of offense, and that blood belongs to that accused person, that we can say that directly the accused has been connected with that weapon of offense, and then he is related to that crime. That's why in similar manner, then when considered to be a rape, you can say that if in the the skin found on the nails, that is also tested in the scientific manner, and that skin found in the nails of an accused, that belongs to the deceased or the victim, then that is also connecting. That is similar manner. When the weapon of offense is also sent to the ballistic expert, then that weapon, whether this weapon has been used in the crime, what type of bore of that weapon, what is the make of that weapon, and that weapon, whether it has been used with the commission of that crime, that is also connected with that forensic evidence. That you can say that the scientific evidence, you can say, when that empty which is found on the spot of the murder particularly, and then you might be seeing that in empty there is some striking pin, and after when that accused is arrested and that accused get that weapon of offense recovered, and in that weapon of offense is sent to the scientific laboratory, that ballistic expert, and that coal, that is called coal, that is empty, which is found on the spot. That scientific officer will check whether this weapon recovered from the accused is connecting with that empty which is found on the spot where the murder took place. Then it means that that evidence which has been collected by the police, that recovery of weapon with the accused, has been connected directly with the spot where the empty was found. This type of evidence is called connecting evidence, that accused is connected with the crime. So these are very important for the purpose of trial. And
sure, I'll come. Sorry to interrupt you.
Want to come in here
I'll come to you. Yeah. Just a brief question that comes to mind is, the way you explained it, obviously it's a very elaborate procedure. Yeah. But since we're talking about delay, if you could also tell us how much of time does all of this require?
Yes, that depends on how many laboratories we have.
Okay.
Because cases are so much, and that the evidence is sent to the laboratories are so many cases, and then that scientific officers which are dealing with those cases, are number of those scientific officers is very less. That all depends upon the government, that they should think about to increase the laboratories, number of laboratories, and to increase the scientific officers who are dealing with such type of, because that scientific evidence is very important evidence which cannot be denied by any court of law if it is proved very easily.
I want to add something. I think it's a very important question, because she said collection of scientific evidence.
Yes.
We're talking about analysis.
Yes.
Let me tell you, the police role plays a very important role in collection of evidence. When there's a murder, there are blood spots. Now, unfortunately, in India, police has no tools. They just have to go visually, khoon yahan tha ki nahi tha, and they're picking it up from the mud. Unlike in other countries, there's a spray, they just spray it. They spray the whole area and the blood spots become fluorescent. So we have absolutely zilch methods of collecting evidence, scientific methods of collecting. It purely depends on the, I would say, expertise of the policeman. He's doing a good job, but he's been not given the equipment. So that is what makes the case more difficult and tricky, and also relates to the economic strata of the accused. And the only method that they use, unfortunately, sir, sorry I have to say it, ki danda maro aur bakwao.
Step decision is very good. but it can't be done in isolation. There is a severe paucity of forensic labs in this country. When I was chairperson of NCW, we did a training for some of the police women, okay? A woman from Darjeeling, a very committed police woman, said that, madam, the distance from Darjeeling to Calcutta is so much that by the time I collect physical evidence in the case, especially of sexual offences, semen, etc., blood, etc., all right, you know, it becomes unviable, which means that the evidence cannot even be used. Then what happens? The other thing is that she says we don't have the equipment always necessary or on hand to collect such evidence, and it's this evidence that ties the crime to the criminal, as he pointed out. The third thing is that if you set a time limit, it's fine, but you also need to make sure that there are enough judges at the courts at all levels. India's jails are filled not only with heinous criminals. The number of under trials in our jails is, well, I don't want to use the word criminal, but it's a shame because there are many people, both men and women, who are just lying there rotting for years.
And they don't know why they're in. They
and
don't
you
even
can't
know
also blame the police. Now, many of the police, even I think police recruitment also, we need to make sure that, you know, the levels of the people who have been recruited into the police, they need an enormous amount of training. Enormous. You can't blame them. If you take 10 standard people, say from a state like Kerala or Andhra, I'm sorry to, you know, I don't mean to sound in any way, make any, you know, prejudicial statements. Compare them to Bihar or UP. Obviously, the guys down south, the education levels are far higher there.
Yes.
So, they may need less training, but the same training is provided to everybody. So, whom do you blame? That's why I say that the system needs a change. It's a systemic failure that is, you know, bringing up all these questions, and rightly so. But I'm very glad the government has taken this step. There has to be a time limit. But behind that, you have to make sure, and unfortunately it's also a state subject, this sort of thing. So both state governments and the central government have to make sure that the people who run or man the justice system have the equipment they need, whether it is information, whether it is labs, whether it is training, whether it's vehicles to get there. In the Nirbhaya case, because it became such a big public, there was such a huge public outcry, remember that the politicians made sure, Sheila Dikshit made sure that this case was done fatafat, as we say in Hindi. Most cases don't have that advantage. Anywhere, I'm not trying to compare one state to another. I'm just saying that we need to have a very practical approach to justice. And the law exists to bring justice. If there are loopholes, then we need to make sure that those loopholes are not used for, you know, what is not correct, but is used instead for justice.
Archana Pathak, as is being pointed out, multiple shortcomings at different levels, investigation, judiciary, there are not enough scientific labs. But, you know, we are talking about those who are on death row. For them, now when they know this is something that is going to happen, there is no way that they can escape the gallows. Despite them, there are efforts to, you know, use all their legal remedies and just try and delay the inevitable. That's where the problem is. I think the public sentiment, public ire is not because justice is being delayed, because the execution is also being delayed, and further kind of, you know, widening the distrust between people and the judiciary. How can that be corrected?
See, as we know, we all are discussing here that the law has to be balanced. So it is now in this particular case that everybody now knows what the loopholes are. Otherwise, till now, nobody knew, you know, curative petition, most of the people, you know, practicing would not know that what these curative petitions are or what these mercy petitions are. You know, so that way, okay, we know now, we have knowledge of all these things. At the same time, we also know the loopholes here. I'll also tell you, you know, particularly about this case, Nirbhaya case, there was a lot of delay caused even when the matter was pending at the High Court, because there the convicts said that, you know, the entire documentation is in English, because the language of the Delhi High Court is English. So we have everything now translated to English and we don't understand. So we need to know what is being read against us. So I'm telling you, just to say that it was a very, very fair trial. Everything was translated for them to Hindi, and then, you know, all this delay, it will take time because it was very, very voluminous. So that was taken care of, so that, you know, why it has to be also accused centric, because later on they don't say that not proper, trial was conducted, and we were not given enough opportunities.
Definitely, and a fair trial is something
a fair
that
trial
our
is
lawyers
also one of the rights of an accused. So that is one. And now what the tactics are being used is definitely it is provided in the system. So I just said earlier, it is nothing illegal that they are doing or anything wrong with the lawyers taking help of those laws, because as lawyers we are there to defend our clients. It is for the judges to decide what is right and wrong. We as lawyers, we are not to decide what is right and wrong. All that we have to do is to present our client before the court in the best possible manner that we can.
Certainly.
That is a lawyer's ethics, if I may say. And the fact that every year this is reminded, and now, as ma'am also said, that earlier they didn't even probably know that death is a confirmed thing for them. Now they have also become little intelligent. So that is why all these, they know everything. I'll also say one thing here, that it is also important that the laws should be made public. The public should be made aware of what the laws are, what are their consequences.
Precisely.
Because see, like we saw in the Hyderabad case, now there is a separate series of cases which is coming up, in which what they are doing is, they are, in cases of gangrape, they are trying to, the victim, they see that she's no more. So that is final, and they also burn the body. So they feel that the scientific evidence cannot be collected, and so they can, somehow the other way they can escape. So they don't know that we have such good, forensic laboratories, which even after the body is burnt, evidence can be collected. So they don't know it. So that is why that is also an extreme step that now being taken. We also have to be, the laws can be very, very strict, but how they are implemented has to be also seen.
Certainly.
मेरा क्वेश्चन चारू मैम से है, जैसे कि निर्भया कांड केस को 7 साल पूरे हो चुके हैं, आपको नहीं लगता है कि 7 साल एक आरोपी को सज़ा देने के लिए बहुत ज़्यादा लंबा वक्त है, और वो भी तब जब सबको पता है कि किसने क्या किया है? मेरे हिसाब से अगर ऐसे केसेस में ढील दी जाती है, तो मेरे को लगता है कि अगर ढील दी जा रही है तो वो आरोपियों को शह दी जा रही है ऐसा काम करने के लिए.
ये public sentiment is all
ये
about that.
public
एक और
sentiment
question
है.
ले लें, then I'll come to you. Yeah.
There is a time limit in the CRPC for the investigation. It should be completed within the time. There must be the trial. It should be completed within the time, especially in the gang rapes. Why there is no time limit in the High Court or in the Supreme Court when the matter is pending? This is the only one reason why this is.
देखिए, ये बात जो आप कह रही हैं, ये पब्लिक सेंटिमेंट है. I think it's very good thing that this Nirbhaya case has highlighted that what is wrong with the law.
Given voice to those cases that can't come to the fore.
I know, it's showing us that in a case which is almost like a watertight case, where there's almost like, investigation is time, everything is time bound, still it's taken 7 years. And most probably maybe by March, the execution death is certain for them, however much they delay. And the debate has started. And now is the time for us to make a course correction in the law. Like you asked the question, and I'm sure Archana will answer better. That now we need to set a time frame. पहले भी आपने कहा था time frame, सब time frame की बात कर रहे हैं. But it's a general. We're not saying कि after how many days trial to be completed. We're not saying how many days High Court has to do it. 90 days is there for him to file the appeal. But we're not saying how many days the Supreme Court has to decide. So now we have to have a full plan. And I think that's what's important, and maybe this petition which the Home Ministry has filed in the Supreme Court, when they say 7 days, it doesn't mean that's going to happen in 7 days. But what it means is that once the court gives an order, there's a good possibility that the court may appoint an amicus or may consider it and give a reply that this is the time frame we're considering. And then, of course, it has to be passed by the
Or maybe it can be
Parliament.
done on a case-to-case basis, as we've seen. I mean, the guidelines...
Why should we be so... we should not do a cherry picking.
To decide on a case-to-case basis. Who's to judge what is worse, what is not worse? For the victim and her family, everything is, worse.
It's horrible for her. Every girl, whether if she's been raped or sexually abused or touched in a wrong manner, it's horrible for her. So let's set the law so that there's no, ambiguity, and it's not कि तुम्हारे लिए ऐसा है, मेरे लिए ऐसा है, इसको share दिया. the law should be even for all. This thought
Archana, you want to answer the question?
I quite agree with that, you know, till a certain level we have the time limit, but after that it is just, you know, let loose. But of course we understand India being such a big country, there are, you know, at every level, the enough number of judges are not there. Even in the cases where there is, like, you know, I'll just give you an example. We have the Consumer Protection Act, and in that the timeline is fixed to decide a particular case. That never happens.
Never happens.
Today, what is happening in consumer courts are, we are given a date which is 1 year later. So I have been given dates of 2021. So even where the statute provides for a date, for a timeline for the courts to decide a matter, nothing is happening. And not even, you know, we can't even move applications for early hearing, and nothing moves because they said, just see the burden of the courts, not enough judges. How do we, you know, we are having 60 cases already in a day. How can we decide more? So these are, you know, we are in a circle. And so one thing happens leads to another, and that's how again we are back at the first position. That vicious circle has to be broken down, and the entire system has to be somehow, you know, made responsible and
accountable.
That's the right
accountability.
word. Responsible and
So
accountable.
ma'am, is delay the only factor which is, you know, against the victims or their families? So when the government talks about making these guidelines victim friendly, apart from the time factor, what are the changes they're looking at?
Look, the time factor today seems to be the major factor. But then, like I said, the training of the police, a lot of crimes do not need to come to court sometimes. There's a lot of very vicious violence that goes on within the four walls of a house, domestic abuse. We have a very, very patriarchal mindset still in this country. I'm sorry to come back to that. It's like a stuck record.
No, but as she rightly said, I mean, it's a vicious circle.
Yeah, it's a vicious circle. So a woman who goes to the police station, regardless of whatever crime may have been committed against her, she is always looked at more as a culprit than as a victim.
Yes.
And it has to start from there. So it's not just a delay. The delay is a huge factor, yes. But it's not just a delay. The delay is also caused because women don't know the law. We often are made to sign an FIR that we don't understand, that we don't read. The victims in this case, not victims, the convicts in this case, in the Nirbhaya case, they have lawyers to tell them that this is it, etc. But most women don't have that. I have had problems when I've asked, you know, a police station, particular police station in the country, to file something, and they say, but you know, the girl just will, or the woman will sign it. And you don't know what are what's been actually written in the FIR. Yeah, that's one thing. And then of course, there's no question of justice there, it's tossed out of the window. So you have, that's why I'm saying accountability. You know, it has to be, the people who man the justice system must also be accountable, right from whether it's the constable or the sub-inspector or whatever it is, upright, and I'm sorry for saying this so bluntly, the Supreme Court. Everybody has to be accountable. There'll be outrage when I say the Supreme Court also, but everybody has to be accountable.
I agree with her that the training part is very important. And
including the politicians. And I say this very consciously.
Refresher courses, time to time refresher courses, when the law is changing, they have to be taught to the police officers. And to them, it is to be taught that how the collection of evidence is to be. That is very important thing. Handling the evidence, you can say physical evidence, is a very important thing. Like we are handling that hair or some other evidence. And as rightly said, that the blood has to be lifted in a very careful manner. It should be shocked and it should dried. And then because the DNA profiling is also very important nowadays coming up. DNA profile is very short evidence. And then that is also to be known to the police officers who are coming up, and the latest, that no doubt training is there, police officers, but at the same time their continuous refreshing about the latest techniques of the scientific investigations and latest laws which are coming up, and what are the lacunas which are pointed out by there are so many guidelines given by the Honorable Supreme Court, Honorable High Court, and those guidelines should also be known to the police officers, and that is a part of training part. That, like in DK Basu case, then how the person's arrested person has right. What are the rights of the arrested person? And that should be known to that person. And in which cases they can arrest him. And day before yesterday, I thought that Telangana High Court that sentenced to one investigating officer who did not follow the law of 41 CRPC. And then he was convicted for 6 months. Then so many things are to be considered. Then the delay is on the part of, because the lack of judges is there, the number of cases are increasing. In CRPC it is mentioned when the trial is started, it should be finished within 6 months. but it never happens. Not in any case, it can end up in 6 months. Even Nirbhaya case also ended more than 1 year or 1.5 years.
Okay, ma'am, I'll come to you. Let me take 2-3 questions from the audience quickly. Yeah.
हेलो मैम, मेरा सवाल अर्चना मैम से है. मैम, अकॉर्डिंग टू लॉ वी आर अलाउड टू हैव अ मर्सी पिटीशन. तो एक्चुअली हम कॉमन पब्लिक के हिसाब से ये चीज़ नहीं होनी चाहिए ना कि सच अ इन रेप केसेस लाइक दे शुड गेट अ परमिशन कि उन्हें मर्सी पिटीशन फाइल करने की परमिशन मिले. तो क्या जो ये 7 years का टाइम लिया था इस केस को एक्चुअली डेथ पेनल्टी तक ले जाने के लिए, तो शुड देयर बी चेंजेस इन आवर लॉ कि ऐसे लोग, मतलब आई एम सॉरी, लाइक रेपिस्ट को मर्सी पिटीशन फाइल करने की परमिशन नहीं मिलनी चाहिए?
देखिए, ये लॉ है. आप जो बात कर रहे हैं, आप चेंजेस की बात कर रहे हैं कि लॉ में दीज काइंड ऑफ चेंजेस शुड बी देयर. Of course, this is a last resort. Mercy there's nothing law about it. It's just, that a person is saying with folded hands that, I'm pleading.
I think the Constitution gives that
the
right to the
Constitution is
convict.
given.
God
But
forgive
of course,
me.
the time, of course, the time frame. I must tell you here that, compared to now and, the previous maybe 10-15 years back, even the mercy petitions to be decided used to take huge
Yes,
time.
yes.
Now they are decided like, within a day or two. So I feel that this is also a very, very positive step, because the thing which was taking years earlier is now decided very, very quickly.
So many
And
so
although there have been no
for
changes
years.
made to that regard, but I just want to add that, a few months ago, the president at one of the events happened to say that
He himself said that there is no need.
Convicts of such heinous crimes shouldn't actually be allowed to file a mercy plea. That's obviously something that he just happened to say at one of the events, but coming from the highest offices.
Yeah. The law can't afford to be emotional. What you are saying now is an emotional reaction, which is absolutely okay. There's nothing wrong with it. But the law has to be unemotional. So you can't, even if, I agree with what you say on an emotional level. I'm totally in sync with you. But the law is not a human being. It's a sort of, it's not even the law cannot afford to be emotional.
It can't run
because
on
there are
public
cases,
sentiment,
as Kiranji just said, that often the poorest person in that list of accused will be the one whom the entire pressure is put on, and he may not necessarily be the criminal. So mistakes can also be made in the process. Now, in the Nirbhaya case, perhaps there wasn't. In the Hyderabad case, it's a different question altogether. The questions being raised on that Hyderabad cases, we don't really know if those were the rapists or not, from a scientific point of view. From an emotional and, obviously if it's not scientific, then the legal thing also comes into questions. Emotionally, yes, we were all very happy ki dekho, we've got immediate justice. But that cannot be, the rule of law. And if there's no rule of law, then there'll be anarchy. Anybody can do anything.
Definitely.
The public also needs to, I have seen in many places, there was a case, Jisha case, for bringing it up in Kerala. I went there for the investigation, for the inquiry from the NCW. It was a little hut where the girl lived and was killed. We were actually standing on the bloodstains. I didn't even know it. When they pointed out me, I almost ran out of that place saying, what are you doing? And the policeman casually says, many people have walked through this, at least 100 people today. And I said, what sort of evidence is there? So finally, the person who was convicted, and then I think he has already been put to death, we really don't know. If you look at it from a very unemotional and very scientific point of view, how do you know? No. So there's a lot of lapses that are going on. All of those need to be dealt with.
Okay, one final round. Yeah, quickly. In the second row, please.
मेरा आपसे क्वेश्चन ये है कि 7 years हो गए इस केस को, बार बार फैसला आता है और बार बार पोस्टपोन्ड हो जाता है, ऐसा क्यों?
बार-बार फैसला आता है और बार-बार
फैसला तो एक ही है।
फैसला तो आ चुका है।
एक ही है।
वो ही
They
मैं
are
कह
just
रही हूँ।
exhausting the
ये
legal
बहुत
remedies
अच्छी-
as we've
ये
been
आपने
discussing.
सवाल अच्छा पूछा है, क्योंकि जो अभी अर्चना जी ने कहा कि वकीलों को भी ये पता चल रहा है कि इतने प्रोसेसेस हैं. So they are only exhausting the legal remedies.
That's what we're talking about. Law provides them multiple options to, file various
Which is why the
petitions.
government is now saying कि time limit चाहिए.
मैम, मेरा क्वेश्चन ये है कि अदर कंट्रीज़ में इसके लिए बहुत जल्दी सज़ा दे दी जाती है, बट जो हमारी कंट्री है, इंडिया जो है, उसमें हम गर्ल को गॉडेस बोलते हैं. उनके साथ ये सब होता है, बट उनको सज़ा इंस्टेंट नहीं दी जाती है. तो ये बहुत ज़्यादा गलत बात है, क्योंकि अदर कंट्रीज़ में इसकी बहुत इमीडिएट एक्शन लिया जाता है इस सज़ा के अगेंस्ट.
In some countries, not all.
Up there. Yeah.
Many
in some
countries
countries
there is quite a bit of delay.
See, you don't want
Yes,
to
but,
compare yourself with Saudi or some country which they have
Yeah.
public beheading. We don't.
You can't
Gandhiji
do that.
said, if we took an eye for an eye, the whole world would be blind. So we
Yes.
have to go according to some rule of law, some process. I understand as young girls, you feel that this may have happened to me. You also feel a fear. Your parents say, "Bahar mat jao," because this can happen. But we must also realize that there has to be a rule of law. Like ma'am said, there'll be anarchy.
What they've all been pointing out is that, you know, obviously there are loopholes which need to be addressed. The reforms is the need of the hour. So what kind of reforms is something that, you know, we can all talk about, and how we can make our justice system more, obviously, in sync, prompt and fair at the same time. Let me begin with you, Archana Pathak.
Yeah, so first, not just the laws, but their implementation as well. Time limit for everything and at every stage. You know, like in capital punishment, so 4 accused, and so everyone will have, their chance to file curative petitions. Maybe what can be done, according to my mind, that, you know, as soon as the first one the remedy is exhausted, there might be an order saying that if anybody wants to file, because see, they're all there, they know, the lawyers know that, you know, in one case this has happened and it's a connected one case. So maybe a timeline can be given right there, that if you want to file, if the others want to file a petition, then that can be done within a month, or whatever the timeline is. After that, we will no longer entertain that. So that can also be there for one particular crime if there are multiple accused, so that this, you know, the loopholes that they are now trying to take advantage of cannot be taken advantage. And of course, a good publicity of the laws, a good publicity of what are the investigating procedures, how the cases are lodged, because like in Hyderabad case, zero FIR, the police station didn't know that there is a concept of zero FIR. I mean, most people don't know. Of course, whatever little we know is because of a Bollywood film that taught us the entire concept of zero FIR. But even then the police didn't know, and the sister of the victim had to run to another police station to get that FIR registered. If that would not have been the case and the zero FIR would have been registered, maybe she would have been alive with us. So that's a very, very, panicky situation.
Ma'am, what do you think? I mean, if we reduce the timeline for punishment in cases where multiple people have been convicted of the same crime, as Archana Pathak points out, will the inordinate delays be taken care of?
Perhaps, but there is also an argument to say that, okay, as of now there is absolutely no time limit, which seems to be being misused. But there has to be a sufficient amount of time also given, because we are presuming that in every case the convicts who have actually been convicted are actually guilty. There have been occasions, not just in India, but I think also all over the world, where the conviction has been overturned. Now, I am not saying it can go on forever. There should be a time limit. The time limit should also be very reasonable. But the other thing that I want to say is that there must be accountability at all levels. This is not there in our country, and it should be brought in. It's a very difficult thing to do, because you will be, actually attacking people who have never been asked questions before.
That's the biggest reform you're talking about.
Yeah, that is really, I think, perhaps the key reform. It will take somebody very, very courageous to do it.
Certainly.
But that is necessary. We can, I mean, how we start, if you even bring it at one level, I think there will be a lot more, people will also, who are actually part of that system, will wake up and understand that justice actually needs to be served, not just, remain in the books. Because there's good and bad and everywhere.
Certainly.
But if accountability can be pushed through, then that could be the most revolutionary reform in any justice system.
Dr. Khanna, how can accountability be brought about?
I'll talk 3 quick things I'll take. One is what Archana said, I totally agree, because just because you have a lot of people who are, lay persons, when a criminal appeal is filed, the whole trial court file comes. And if there are 3 or 4 convicts or accused, each one's role is decided by the judge. So I don't think that there's a necessity in an appeal or a curative or a review for each one to file it separately. Because in any case, the court is seeing it vis-a-vis all the role of all the accused. So that is the first point. The second, what you're talking about, accountability, I totally agree with you, because I'm a lawyer and I have doctor friends, and they say we sit in the government OPD from morning to night. We start operating at 6 o'clock in the morning until 12 o'clock at night. In government hospitals they're operating. What about your judges? So I have no answer for that. And maybe the cricket team, like somebody said, plays more matches. IPL plays.
They play more matches than what the judges, the number of days the judges
I don't want to
sit
make
in.
any comment on anybody else. But my most
really
important
necessary.
reform, which I think, you know, we talk about mindset. Again and again, this whole thing about patriarchy. I say mindset. Every time there's an incident, they say mindset badalna. I said mindset is not a laddu ki aapne khila diya. It's an intergenerational change. What are we doing? For the past almost 20, I think 30 years, 2 decades, every time there's a crime, we talk. Pre-Nirbhaya, let's say 7 years. Have they made any change in the educational system?
Needs a huge
Do you know the laws? Do the boys, are they sensitive that the girl is equal to me or the castes are equal? No. Because what is a child in a rural area when they are born? Sabse pehle kya seekhta hai? You are a boy, you are a girl. They learn religion. They learn jaat. Then they learn क्या खाना चाहिए क्या नहीं. Where do they learn? किसको पहले? So where do they learn the constitutional principles? Where do they learn what is Indianness, what is equality, fraternity, justice? I think this we should stress in the first 5 years of education. This is all they need to teach, and we'll have a better society.
Child being born, along with that 100 days thing. You need to start teaching civic values to
from
our children.
You know, and you have a different India, totally different
Dr. Rao,
India.
one final comment from you as to how to take it forward. Obviously, we're all, you know, on the same page when it comes to taking care of delays which are happening at the judiciary level, at different levels to say, and there are several reforms that we're all talking about. What is the best way forward to take it ahead?
Best way forward is that there is concentrated, consolidated efforts by all the stakeholders like police, judiciary system, government and the public in all large. If they all are coming together and find out the solutions, and the solutions are implemented in real sense, and wherever the person is held responsible for that, then the responsibility, as ma'am rightly said, that responsibility should also be fixed on each and every level, so that, and the exemplary punishment should be done whosoever is not found complying with the responsibility which has been given to him or her. So these are things which are very important to improve the situation. And one more thing, I was just I am little bit different between that the judges are taking later time. No, as Mrs. Pathak must be knowing that the judges has to write so many big judgments, and they are so busy. And I can show you the cause list of the judges. More than 100, more than 150 cases are in one day.
But the number of days they are working.
Number of days, yes, definitely number of days. I agree with that. But the
increase the number of judges.
The work on their...
increase the number of judges.
Yes, I'm saying
and
that
try and dispose of cases as quickly as
possible. Needs to be shaken up.
Certainly.
Their leave period should also be reduced.
So
but definitely they are overburdened with the work. That I agree. They are overburdened with the cases. They are
the amount of cases they are deciding per day. A normal human
definitely
being.
we are confused, and while they are writing the judgments, I can say that judgments in 100 pages, 200 pages, so many other things. And those things also, that the government should also think about recruiting the more and more judges, creating more and more courts. And one thing also I wanted to point it out, that the delay is not only towards the victim, that is also towards the accused also, because the delay, once the accused is found finally not guilty, then who will
under trials.
Yes, under trials. Then so many people are, in one case I found that person was in jail for 12 years and finally he was acquitted.
Obviously, so
then
delay at both levels, it harms
12
both
years,
sides.
golden period 12 years. So that the delay is on the part of both of them. That delay should not be done, and that the government should think about to curtail this delay.
And even for the death penalty, I mean, as a human rights activist, she would agree with me that once you know that's inevitable, you have to, you know, your death penalty can't be overturned. But keeping them waiting for so long is, I think, in that mental state is also unfair to them when we talk about constitutional rights. So huge reforms we've all been talking about. Our panelists have suggested there are various shortcomings, but then accountability is the biggest one at different levels that has to be set rightly. Thank you to all our audience members for joining us on the program today, asking questions to our panelists. And of course, thank you to all of you as well for putting things into perspective so simply, so beautifully for all of us. So that's it from us on the show this week. Just in case you missed the television broadcast, let me remind you that you can also watch it online on YouTube and Twitter. And you can also send us your feedback and suggestions about the program. Thank you for your time.